And the Equality Act 2010 stops people discriminating against other people, but only in very, very, very specific situations. And it's something that it's a law that is very misunderstood by lawyers as well as non-lawyers, because the situations are really so specific, and it's not intuitive really. So not everybody is protected from discrimination. Only people with certain protected characteristics, as they're called, are protected from discrimination. So you'll see that sex is one of them, and importantly, sex rather than gender is the way that it's defined in the Equality Act. That is to say, it's a kind of biological way of defining it, which is slightly controversial amongst some people, or welcomed amongst others, but that's what the law says. But there are other protected characteristics that might be relevant in this context of sex discrimination in renting. One of those is age, because there can be discriminating against people who have children, for example, and that might be unlawful. And another one is marriage and civil partnership, or crucially, pregnancy and maternity. So discrimination against anybody with these protected characteristics for a reason to do with this protected characteristic isn't allowed, but it unfortunately is nowhere near as simple as that. So the most obvious one, and the kind of scenario that everybody thinks of when they think about unlawful discrimination, is direct discrimination, which is a person discriminating against another person because of a protected characteristic. So somebody treating somebody less favourably than they would treat others. So that's probably what most people think of when we think about discrimination. And what I've put up here is a link to a case by Shelter, actually. This case by Shelter didn't use the Equality Act, as far as I can see. They used the Property Ombudsman's rules, but this was finding that basically policies against letting properties to children was unlawful because it broke the Property Ombudsman's code of conduct. But I think that is also an example of direct discrimination, and that's a really, really excellent case. And that's such a common scenario that letting agents and landlords say, sorry, no, we're not going to let to people with children. That is unlawful, especially if the property is completely suitable for children and that has, more than one room, etc. So it's not only landlords who are not allowed to discriminate under the Equality Act. In fact, nobody is allowed to directly discriminate, whatever their status, but letting agents have a sort of specific section in the Act, not for letting agents in particular, but under the heading of service providers. So service providers, as letting agents are not allowed to refuse services based on protected characteristics or to harass or victimise those they're providing a service to. So if a letting agent is harassing or victimising somebody based on their sex or based on another protected characteristic, rather than just being a horrible person in general, then that's unlawful under the Act. And likewise, refusing services based on protected characteristics is not allowed. So if a letting agent, rather than the landlord, is saying, no, we don't deal with anybody with children, A, that's an age discrimination issue, and B, most likely somebody with children looking to let is going to be a woman statistically. So either way, or also pregnant people as well. So if a letting agent discriminates against you, you can make a complaint to the letting agent themselves, which might not be much use, but then you can escalate that back to their redress scheme if no action is taken, and then action should be taken against the letting agent, and letting agents should be a member of a redress scheme, and you can find that on their website. And if they're not, you can make a complaint to trading standards, who should be able to take some action. So there is a route in relation to letting agents. And then there are specific rules relating to landlords, basically, because there are rules about premises and managing premises. So same thing again, you're not allowed to discriminate on the terms of letting premises. So that means you're not allowed to say, I'm not going to let property to you because you have a family. Also means I'm not allowed to charge you more rent, for example, because you have children, because that would be a term of letting. Or you can't say even I'm going to take a higher deposit from you because you have children, because that would also be a term of letting based on a protected characteristic. So you can't change the terms of the contract based on somebody's protected characteristic. So a landlord or agent could say, for example, I'm going to charge you a higher deposit because you've got a dog, because having a pet isn't a protected characteristic. But you can't say I'm going to charge you a higher deposit because you have a child, because that potentially is. And a landlord can't harass anyone who occupies the premises or applies to occupy the premises. Harassment is a kind of separate law in itself that you're not allowed to do, but specifically you're not allowed to do harassment based on somebody's sex or pregnancy or age or anything like that. So specifically, somebody who manages premises can't discriminate against people by the way they allow to use them. So they can't put specific terms on them. They certainly can't evict somebody or take steps to evict somebody based on their protected characteristic. Really, really frequently, people call my firm with inquiries saying, my landlord's trying to evict me and they're kind of harassing me and I want to sue them for this. And in most cases, even though it's really, really horrible to be threatened with eviction and you do feel very harassed in that scenario, it is not unlawful to try and take some steps to do a lawful action, such as lawfully evict somebody via court. But if the motivation for that eviction is something to do with sex or discrimination or another protected characteristic, then that is unlawful. And then that can be used to A, defend the possession proceedings to stop the eviction, and B, potentially take a counterclaim to get some money. So say, for example, somebody became pregnant and the landlord found out, and then the landlord served a Section 21 notice. If you could prove that the motivation for that serving of a Section 21 notice was the pregnancy, which would usually be quite hard to prove because landlords aren't usually quite so stupid as to tell you, but sometimes they are. If you could prove that, then that would be a defence to the possession proceedings, because that would be an unlawful act in seeking to evict somebody. So to go back to the act here, the landlord can't subject the protected person with a protected characteristic to any other detriment based on that. So basically, you just can't do anything bad to somebody that you wouldn't do to somebody else based on their protected characteristic. And you can't harass anybody who occupies the premises or anyone who applies to occupy the premises. So how do you use the Equality Act? So you can sue to get damages, which is compensation for pain, suffering and inconvenience, which is in general about a range of bands from about £990 to about £49,300, plus any actual financial losses that you've had as a result. You can get a declaration or an injunction to change the behaviour, so to stop the landlord trying to apply a different term to the tenancy or trying to evict you, and it can be a defence to possession proceedings. Now, I'm afraid none of this is straightforward whatsoever. Equality Act claims are really, really, really technically difficult, and legal aid is available for them, and it's quite clearly available for them where it's linked to something like a defence to possession proceedings. But for a standalone claim for damages, it's only going to be available if it's very much linked to, in the housing context anyway, if it's linked to a housing case and it's worth quite a lot of money, because you have to prove basically that you're going to get 3 times as much money in compensation as the legal aid costs are going to cost, which is often not the case because these cases are really difficult and complicated and take years. Or that you're asking for a declaration or injunction, which is going to do something like keep a roof over somebody's head or prevent them from being homeless.
At Anthony Gold Solicitors, we specialise in tenants' rights, and with our dedicated team of legal experts, we'll examine your situation, guide you through the process, and fight passionately to ensure that your rights are protected. Reach out to us today by calling 0207 940 4060 or visit anthonygold.co.uk and fill out the Contact Us form.